So this is the first of a series of legal webinars that LUPC are organising under UK UPC, and we'll be running these every 2 months. So it's good to have you here on the first event that is with Bevan Britton. So Bevan Britton will introduce themselves shortly. And like I say, Q&As, please put them in the Q&A section, not the chat section. And Bevan Britton are on lot 4 of the LUPC legal framework that is open to all members except for APUC that have their own legal framework agreement. Okay, so now if I can hand across to Neve.
Good morning, everybody. I'm sure that a couple of you may know me because I know I've worked with a couple of people that have signed up. But if not, my name is Neve Batterton. I'm a construction lawyer from Bevan Britton. So thanks for your time today. Obviously, it's quite a topical issue. There's inflation going on everywhere, and it's affecting us in day-to-day and in construction contracts. So I just thought I'd give you a quick introduction to the Bevan Britton construction team. We consist of a non-contentious construction team which deals with all the transactional work, and then we also have a contentious team which deals with all of the litigious work. In total, we've got 19 lawyers across 4 offices, London, Leeds, Bristol and Birmingham, and the current head of construction is Andrew Tobin. So his details are there, and I'm sure the slides can be passed to you afterwards if you need them. Just a little bit about myself. I joined Bevan Britton about 1.5 years ago. Prior to that, I was dealing with private client, and I'm 15 years qualified. I'm a legal director. I'm based in the Leeds office. I live in York. And most of my work is employer and developer led. So I would act for the person that's actually building the building as opposed to the contractual side, so for contractors and subcontractors. I have a broad range of clients. Bevan Britton is quite a public authority housing firm, and so my clients includes a lot of local authorities, for example, North Yorkshire Council, Oxford Council. I concentrate a lot on higher education clients. Current clients are University of York and Oxford University, amongst some. And also I do a lot of work for housing associations such as Sovereign, Together Housing, etc. And then again, private corporate entities, the likes of Siemens that we built for as well. And so my job is to prepare all the construction contracts based on JCT, NEC. I'd also prepare all of the consultancy appointments for the professional team, any warranties that they were to deliver at the end, novation, security documents, and development agreements. So that's just a quick, brief introduction to myself. So what we're going to talk about today is the current market and where we're at and how inflation is affecting our construction sector. What can we do to address this in our contracts, and how can we vary our contracts? What are the risks being associated with contractors as well? And how can we protect ourselves from contractor insolvency and other actions to generally try and address inflation? There's no magic answer. It's affecting everybody, and the risk involved is associated with both parties. So just looking at first the current market, there are obviously various external global factors impacting on the construction industry, curtailing the supply of goods and materials, so Brexit, COVID, and the war in the Ukraine. The UK and European construction markets are wrestling with disrupted trade and supply chains and increasing competition for limited resources. As a result, resources become more limited than usual, ports are becoming congested, and competition for materials has increased greatly. Higher prices for commodities like steel and energy have filtered into the construction materials and components, which has pushed up tender price inflation. The increased cost in materials and labour in turn results in contractors increasing the prices for their bids, and the market becoming less competitive. Reduced construction confidence and higher investor uncertainty has also resulted in tighter financial conditions, and funders are less willing to invest in construction projects without strict contingencies. There is also an overall restriction on construction growth prospects, and ongoing projects are being delayed as they adjust to a shortage of materials, labour and funding. And this is all coupled with a construction workforce shrinkage, where an ageing cohort of skilled workers are either retiring, or some other skilled workers are moving to different employment where there are more competitive salaries. So all of the above results in extended timelines for projects, as contractors will not have a clear supply chain for materials they need unless they pay extortionate prices. The knock-on effect of this is an increase in uncertainty over completion dates, and then an increased difficulty in estimating the future cost of projects. So from Brexit to COVID, the construction industry has been preparing itself for a steady increase in construction prices. However, following the war in the Ukraine, this steady increase has then turned into a sharp incline. Nearly every facet of the construction project, from the price and availability of materials to import costs, are now feeling the severe brunt of the price of inflation. So to give some perspective on the market in its current form, there has been a near unanimous increase in materials costs used across construction projects. In March of this year, the price of crude oil increased by 99.4%, diesel by 33.8%, and unleaded fuel by 30.5%. In turn, materials like bricks, ceramics, cement, plastics and steels, which require high amounts of energy, are at high risk of further escalation. There has also been a 66% increase in fabricated steel, and there's been a 500% increase in oriental strand board, which is an engineered wood board required in a lot of construction projects. And as a result of all of this, bid prices have increased by 8.5% this year. Since most contractors already operate on slim margins, increased costs are impacting on the bidding process. The steep recent price increases make it extremely difficult to estimate future costs, which may be several times the original estimates that have been given at the tender stage. And there may be even more when the job completes. And delays in getting materials to site and by supply chains mean that the timeline for project completions is often unclear. If contractors don't increase their fees, they then have to absorb the increased cost, resulting in slimmer margins and then an increased risk of going into liquidity. As the construction industry is currently in uncharted waters, there is no single solution or easy fix when drafting construction contracts. Nevertheless, there are some options. So I'm going to run through some of the contract options with you now. I'll just apologies. So the first thing we're going to look at is provisional sums. The vast majority of construction contracts in the UK are either lump sum or fixed price contracts, and they contain various mechanisms for price increases, so for example, variations, but they don't usually deal with price inflation. Construction contracts can instead have provisional sums included in them to tackle increase in prices. These sums are included in contract specifications and are the estimate of the likely cost of work that either cannot be sufficiently defined at the time of contracting, or works that the employer or the client may choose not to undertake. These can be included in the specifications to the JCT and in NEC option A. So in the JCT, we tick a box in the contract particulars which says that provisional sums apply, and then the details where they can be put are put in the specifications to the JCT. And likewise with NEC option A, that's chosen and therefore provisional sums are applicable. There are two types of provisional sums: undefined provisional sums, where the client typically bears the price and scheduling risks, and defined provisional sums are those which have been described in sufficient detail that the contractor is expected to have made an allowance for them in their programming, planning and pricing preliminaries. Provisional sums can be drafted very precisely to achieve exactly what the parties require. For example, employers and contractors should carefully consider the following: the value of provisional sums when they are entered into specific specifications for the works, as they could substantially increase in price of the project. Any contingency in budgets to allow for substantive increases to provisional sums and any approvals needed from funders. The method for instructing or allowing a change to provisional sums, as this varies between standard form contracts, and the impact of provisional sum discussions on the programme for a project. A helpful solution would be to have particularly defined provisional sums and a risk register so that the employer and contractor try to identify, ring fence and actively collaborate to manage the risk. So for example, if the employer was to buy in bulk very early in the programme, this might be one area that they would identify. Our risk register is a list of risks that could affect a project and is a key tool in successful project management under NEC contracts, but you could draft them into a JCT contract if necessary. The second type of thing that we're going to look at today that may help in contracting is fluctuation provisions. So until the last 6 months, we never used fluctuation provisions in JCT. It just wasn't really heard of. And obviously now contractors are asking for them. One of the things to consider is to retrospectively introduce fluctuation provisions and retrospectively amend contracts. And this is one thing we are being asked to do by some local authority clients at the moment. Construction contracts can be drafted to include fluctuation provisions. A fluctuation provision is a compensatory clause in a construction contract that allows the contract price to be adjusted to reflect changes in the cost of materials or labour during the construction period. Different contracts tend to deal with fluctuation provisions in different ways. For example, JCT includes this in its contract particulars, whereas NEC has a second option X1 that would need to be selected when the contract documents are assembled. So again, with the JCT, we would tick in the contract particulars where the fluctuation provisions apply and which fluctuation provisions apply. And likewise then, when setting up the NEC contract, we tick that the secondary option X1 applies. The benefits of a fluctuation provision is that drafting can be tailored for the circumstances. So for example, we could only allow a fluctuation provision for specifically identified materials, which are at higher risk of a price increase, for example, steel. Most fluctuation provisions are calculated by reference to a public price index. So that's how they generally tend to work. The key message is that adopting a fluctuation provision does not mean limitless cost exposure for the employer or unrestricted recovery for the contractor. The benefit to the employer is that he may not be adopting much more risk than he would have already undertaken under a lump sum contract, but he's attracting more economically priced tenders that he otherwise would have not been able to obtain. The benefit to the contractor is that he is no longer required to price for a risk, which if the length of the project was over several years, he may not be able to adequately foresee. So obviously we have different options in NEC. We've got NEC option A, and that deals with changes to tax levies and contributions. Option B deals with changes to the price of labour and material costs. And then option C is based on a formula which is similar to the JCT fluctuation provisions. Another important thing to remember when you are setting up your fluctuation provisions is your base date. It's very important because it's the nucleus for determining any adjustment to the contract sum. So other options that we could use, not used as much, and I don't have a huge amount of experience in these particular contracts, more so with fluctuations and provisional sums, is the using of a cost plus or a target cost contract. So another way to address significant changes in material prices is to consider a cost plus contract. In this situation, the contractor is reimbursed for the actual cost incurred for plant, materials and labour on a project, plus an additional fee to account for the contractor's overheads and profit. The contractor could therefore pass on all increases to the employer or the client. So therefore, the client is taking all the risk in that instance. Examples of cost plus contracts are NEC option E, the JCT prime cost building contract, and the FIDIC short form contract. These are traditionally not very appealing to developers, as the primary risk of uncertainty of the final cost of the work and the increased difficulty in funding that could be a problem for the employer. There's also the option for the target cost contracts. This is a mechanism which is written into a construction contract, which gives the contractor increased profits in the work. And if the work is provided cheaper, they'll get their increased profits. However, if the contractor goes over budget, they will be penalised. And examples of these are NEC option C and D and ICME Burgundy Book. Another option also is bespoke drafting in contracts. I've done a lot of this for clients. So for example, we might just add in the increase of the price of steel and reference it to loss and expense. And therefore, if there is an increase in the price of steel, it will be adjusted by the, I don't know why my screen has stopped sharing. If you can just give me a second.
No problem. I was just about to say, Neve, that it's stopped sharing at the moment.
Yeah, we don't know why that has happened. That's quite strange. Okay, I'll continue anyway. So bespoke drafting, basically, you can put it in. You could put in a share gain, pain gain mechanism. So 50% of the increase goes to the employer and 50% of the increase goes to the contractor. So we've recently done that in a development agreement whereby the build hasn't even started yet. The development agreement was put in place in April of this year, and it's still going to take some time. So therefore, there is a big risk. And then we've capped the overall risk so that at one point, when it reaches a certain amount, then our client no longer takes the risk of that increase in inflation, and the contractor does. The other things to consider in relation to this whole thing and the risk to the contractor are contractor insolvencies. So with contractor insolvencies, the best way to deal with this is for the developer to do its credit checks on the contractor. So they'll need to be more conscious than ever when engaging contractors, and therefore avoid this risk of insolvency. The market for contractors and subcontractors is unfortunately bleak. Increased prices of materials and labour and supply chain issues increase the risk of contractors becoming insolvent because they have to absorb the increased costs into their already slim margins, and then this affects their liquidity. Alternatively, to avoid insolvency, contractors are increasing their bid prices, as I previously mentioned.
Neve, can I just interrupt you there? I'm sharing my screen now with a copy of your slides. So
that's great. Thank you very much. If you can fast forward a couple of slides until we get to insolvency. Yeah, that's it. Back one.
Oh, back one.
Yeah, okay. So the other ways to protect yourself at the moment is to look at the forms of security you can get from contractors. The first one being bonds. One of the issues at the moment is that bond securities or bond providers are not willing to provide bonds unless it's to a big contractor, which can cause problems. So just a bit of explanation around bonds. Performance bonds act as a guarantee over the performance of a contractor's obligations. Should the contractor default on such obligations, the client will, in theory, and subject to the terms of the bonds, have a quick and efficient remedy to the contractor's breach by liquidating the bond. The proceeds may then be used by the client in respect of the works. So drafting notes for a bond, if you are getting a bond, it should be at least 10%. It should be an on-demand bond so that you don't have to establish that you have a claim before you can liquidate bonds. So sometimes a contractor will come forward with an ABI form of bonds. We as lawyers reject that and will put forward our own form of bond. If they insist upon an ABI form of bonds, then these would usually be amended and tailored to suit the conditions. And also the bond shouldn't expire any sooner than 3 months post practical completion in case there's any issues post PC. If sometimes a client will come to me and they'll ask if they can have a bond or a PCG, I would always say ask for both, because I think that's really important. So there's no harm at the outset in asking for both. If a company comes back and they say we don't have a parent company, there's nothing that can be done about that, and we would then obviously opt for the bonds. Some clients ask if we get offered one or the other, which should we accept? And my advice would be that you've got to weigh up all the options and look at the strength of the bonds and the strength of the parent company. So it would always be a commercial decision, but you should always ask for both. Effectively, a parent company guarantee will not cost anything to provide. However, I have come across contractors who will say, oh, we don't offer them. And when we've pushed hard, they've actually produced the parent company guarantee. So I would advise that you really insist upon one. Again, when drafting the parent company guarantee, normally go to your lawyer who will provide a good form of parent company guarantee. And you want the parent company's liability to be coextensive with that of the contractors, which will usually be 12 years. So do check the expiry on your parent company guarantee. So how does it work in practice? If the contractor becomes insolvent or fails to carry out their duties, the parent company must step in and honour the contract and fulfil any debts. Another form of security that you can consider at the moment is an advance payment bonds. So an advance payment bond will usually assist where there's a requirement to purchase materials in advance of a contract commencing. Usually if there's any pre-orders, we used to get advance payment bonds, but now as developers are strategically bulk ordering, it's best to get advance payment bonds. An APB protects the payment amount being advanced in exchange for a bond, and this is underpinned by a suitable guarantor to give peace of mind to both parties. There is a cost associated with the bonds, but it does assist with the cash flow of the contractor, and then it protects the employer. And if you look at your contract terms, you may find that an APB is already a contractual obligation. And if it isn't, you could build it into a letter of intent at the outset and then pass it over into the main contract when you enter the main contract. In practice, once a bond is issued by the guarantor, the employer can then release the monies. And APB bonds can be on-demand bonds also. Sometimes when there is an APB due to a pre-order and the goods are sitting with a separate manufacturer, there's no contractual link between the employer and the manufacturer. And if that's the case, then we would usually seek a vesting certificate at that point. So this is coupled usually with an APB. A vesting certificate is an agreement for construction goods, plants or materials, and it's usually in a letter form, and it confirms the ownership of the goods, plants and materials, and that they will transfer from one party to another. They're fairly straightforward to draft, and you need to ensure that there's an insurance clause in there and that dictates that the person providing the vesting certificate has insured all the goods for fire, damage, theft, and will reimburse the owner in the event of an insurance payout. So that's quite fundamental in a vesting certificate. As I mentioned earlier, other areas for employers to consider are contractor credit checks. And this will mitigate the increased risk of being affected by a contractor becoming insolvent. Therefore, the developer should perform its credit reference checks on everybody involved, including the parent company, in a project, and assess their risk of going insolvent before the likely end of the date of the project. They should also ensure that there are sufficient insurance levels in place for all contractors and subcontractors. And they should also be willing to negotiate a higher fee if it results in securing performance bonds. So in conclusion, really, when we look at everything that's happening at the moment, what does this mean for the construction industry? Steep recent price increases make it extremely difficult to estimate future costs, which may be several times the original estimates by the time the work commences, and even more by the time the job is completed. Delays in getting materials on site due to supply chain challenges often mean that the timeline for a project's completion is often unclear. The risk of inflation is borne by the contractors. In these situations, incorrectly pricing costs into a bid can have catastrophic effects on their budgets and then push them into liquidity. The risks to non-contractor clients are increased bid prices, delays in completion, and contractors potentially going out of business. And all of this in turn increases the cost for the client. Developers may now struggle to secure funding for projects. For example, they will have increased questions regarding the profitability of projects. And clients may be less willing to start new projects in an unclear environment, and then this leads to deferrals and delays. In the face of such acute uncertainty, an increasing number of suppliers are not able to fix prices, and in many cases, contractors are adding significant risk allowances on projects that are currently being tendered to compensate for market volatility and price fluctuations. So the possible actions to address inflation, consider risk sharing under contracts. We can't push everything onto the contractor because, as I said above, it then leads to this issue of insolvency, and then that's more cost for the developer client. So in considering risk sharing under contracts, consider the risk of inflation under the contract conditions, whether this is through an alliance style agreements or alternate contract conditions, as we mentioned. And this means that contractors are more likely to bid on projects and less likely to go bust. And it also means an increased risk and cost to the client. Also revisit insurance policies. Higher prices for materials and labours will be reflected in the final cost of the project. And since losses will also lead to more expensive rebuilds, the sums insured may need to be revised to minimise the risk of being underinsured. And finally, consider supply chain challenges and review your timelines because they may need to be more realistic. Oh, and one other point, to reassess your material procurement procedures. So, for example, the benefits of stockpiling. So some of the points that we've raised today have come about from questions that we are currently being asked by clients. So one client going out and doing a massive pre-order in cash for some bricks, and they couldn't get an APB bond. Eventually we managed to get one, a letter of intent, an APB bond and a vesting certificate. Another client, as I mentioned, has entered into a development agreement, and its biggest concern back in April was the increase in the price of steel, and so we've put in bespoke clauses to deal with that. Another client has come to us, and their current developer would like option X1 to be put back into their NEC contracts that are already in place, and we're doing this by deeds of variation. So they can be dealt with retrospectively, and I think it just shows that there has to be some sort of leeway for contractors, because there's a lot of pressure on them, and risk sharing really has to be considered. So I hope this has helped. I know that we've gone under time, but if anybody has any questions, please do ask. And sorry about the slideshow.
Thank you, Neve. Yeah, IT always a challenge, but hopefully it wasn't too much of an inconvenience for those on the call. We do have a few questions that have come through. If anyone does have any questions, please add them to the Q&A button side so I can then see those and then ask.
Well, I can see actually one from Helen at Bristol, and that's a really good question actually. How do we deal with the bank holiday coming up this Monday in any T4 contract? Bank holidays are probably already defined in there, and we'd also have to look at any statutory changes under the base date, after the base date, and if we, the employer, are at risk of statutory changes under the base date, you'd query whether putting in a new bank holiday is a statutory change, and therefore that may now be at the risk of the employer. So we'd have to look at the exact details of the contract to be able to answer that. But my gut feeling would be that it's going to be at the employer's risk. But happy to have a quick look at it if you want, Helen. That's absolutely fine.
Okay.
Next one, what can we do if we have entered into a contract and the contractor is now insisting upon inflation and that they're not entitled to? Well, first of all, we can do nothing, and we can allow them to take that risk, but then we have to consider it up against the price of that contractor going bust or having serious cash flow problems, and therefore we may be at risk ourselves. And so, as I mentioned, I think a deed of variation and coming up with a solution that would deal with the risk sharing of inflation and retrospectively amending your contract from a certain date to take effect. Stuart. This all paints a fairly bleak picture in terms of risks. Are there any examples of positive experienced recently in the construction industry? Stuart, I can't think of any. However, I would think that maybe employers showing that they're willing to compromise and share inflation does help, but I can't think of any particular examples off the top of my head, so I'm apologies. It is a very bleak outlook at the moment. Mark Pearson, how do contracting authorities bound by the public contracts regulation pre-order key materials, which is ultimately will be part of the property tender main contract? Will the contracting authority have to comply with the PCRs when tendering for the advanced materials purchases? I suspect so, Mark. I'm not a procurement lawyer, and so if a client would come to me with this question, I would automatically go to either Matt Moe or Scott Cousins in my in BB team and ask them, because I'm not qualified in that area, but I am happy to pass the question on to them and as a general and ask them to respond, and I'm happy to email you afterwards as well, so that will be fine.
I was going to say if it's possible to do that afterwards, and then we can get that sent out to everyone.
Yeah, I just can't give advice on an area I'm not qualified in, but I will try and find the answer for you.
No problem.
Andy Davies, do APBs carry a charge like performance bonds? What do they tend to cost? Yes, they do carry a charge. I'm not just trying to think. I've not come across the charge. When we deal with performance bonds and APBs, we as lawyers generally tend to get involved in the actual cost. We're more involved in the drafting, and so that's left between the client. So I don't know. Again, I can find out, and I can email you, and that's fine. So hopefully Roy can keep a list of all these questions and people's names, and I'm happy to deal with answers over the next week for ones that I can't answer, so apologies. And Yusuf, in the case of public sector clients, inflationary pressure will likely lead to increases in contract values above their originally advertised values. How can we best incorporate price fluctuations into our contract notices? Again, Yusuf, that will be one for procurement. It might be that we somehow have to get our procurement team to put a paper together dealing with these public authority questions about pre-orders and increases, so that they're not breaching any procurement regulations and how they deal with it. So again, I can pass that on. Apologies for not being able to answer. Stephen Howells, insurers are looking negatively at construction. Do you feel that the issue of obtaining insurance is impacting on contracts? It's impacting on our drafting. We are being led a lot by what the insurers require. They're having more power now to be able to dictate what we put in contracts. For example, when they exclude their liability for fire, we have to put those types of things in as well. So it's an insurer's market, as it is a contractor's at the moment, and we are having to heavily negotiate contracts and sometimes comply with the insurer's requirements because they are pushing a hard deal. Do you anticipate seeing more elaborate target cost pay and gain share models as a result of enduring challenges? I'm not very sure on that one. I have limited experience in target cost contracts. Again, I can put it back to my team and ask them. Helen, we tend to tender advanced materials and then novate the contractor to place the actual order. I don't know that your answer, sorry. Apologies, I can't really see the rest of that question.
I think it's just actually as short as that. So I don't know if Helen was adding something further down. Helen, if you could submit a clarification on that, it'd be appreciated. To move to Owen Rees.
Another procurement related one. Is a compensation event under the NEC considered a modification under public procurement regulations? Or is it considered a provision which sits outside the modifications issue? Just thinking if we are required to increase contract price to the extent which breaches requirements. So I would think that it does sit outside because there are various compensation events under the NEC. And you couldn't risk breaching the public procurement regulations. But again, I can put this particular question to my colleagues and put it on a set paper. And what I'll do is we can even circulate it to, along with a note that I'm going to prepare, post this on what I've talked about today and the procurement issues. And we can put them all in one paper and circulate to people on here if they want them.
Indeed, I think that would be the best thing. We'll send that to all.
Yeah, because I've been asked to write set for our HE publications, and once I've done that, then we can issue it along with an answer to the procurement questions. I'm so sorry I can't answer those, but I'm just not equipped with the knowledge to answer those.
That's okay. Okay.
It was a response to an earlier question about how do you procure under PCR. We tend to tender non-PCR advanced materials and then novate the contractor in place. I'll have to put it together with the question, Helen. Apologies, I can't find the previous question. Yes, Howard has asked, does the BCIS public sector price and cost indices still tend to be used in most situations that I've experienced? Howard, yes, we do refer to the BCIS and public sector price when I've been dealing with indices. Which is better, a bond or a PCG, if we can't get both? So as I mentioned, they serve very different purposes. Bonds, 10% of the contract value. It can be called upon on demand. You really need to look at your drafting when it comes to a bond. Avoid ABI forms of bonds. If they insist upon them, get them amended. You do not want to have to establish a claim before you can call on the bonds, because it will be very time consuming and you may not be able to call on the bonds. A parent company, if you've got a strong parent company, or you can sometimes get maybe a sister company guarantee, they will step in. And again, you have to look at your drafting because you want them to not only deal with the performance under the contract, but you also want them to deal with any debt due to you under the contract. So look for a good, strong parent company guarantee, look for your drafting, always ensure that it is coextensive with the contractor's liability and that would never be less than that. So therefore, you've got one that's in place until the end of your contract, usually 3 months after PC, and then one that will be in place for 12 years. So should 2 years down the line, the contractor go bust and something happen, you could bring a claim against the parent company. So it's a case of weighing up the price of the bonds and what both give you in the instance, weighed up against the project and everything else that you're dealing with. If it was a very short project, and there's less likelihood of a contractor going bust in 6 months, then it might be better to get bonds. But I would always say, I push back on when they say we can't give you a PCG. A PCG doesn't cost them anything. And I know specific contractors who will say, we don't offer PCGs. And when I've pushed and said, well, I've worked on another matter where you have, they've taken a back step and they've offered the PCG. And sometimes when they don't, I'll go to the client and say, can you have that discussion at commercial level, please? And see if the MD or whoever will then consider a parent company guarantee. So do always push for both, always ask for both in the outset in your contract drafting. Under a JCT, you just tick boxes for the form of bonds and for in the contract particulars that they are required. However, most JCTs nowadays would come with a set of special conditions from your lawyer, and in there we would specifically ask them within so many days of entering into your contract, and then we would append the forms to be used, and we would also stipulate the amount the bonds got to be and the expiry. And sometimes it would be a breach of contract if the contractor has not provided a bond and a PCG when they were asked to provide it.
I've got one that's still open here from Yusuf. I'm not too sure. Did you respond to the Yusuf question that's there about?
Are you able to provide guidance on how to structure clauses relating to price indexation? How to structure clauses? Our experience shows contractors understand these differently in terms of calculations, so it'll be good to see some practice examples. I can have a look at Yusuf and go back to my team in terms of what drafting they've been doing for JCT fluctuations and how they've altered that specific wording. And again, Roy, if you can, I don't know whether you can print or somehow save a list of all these questions.
We'll have an output from all of these questions, and then we can just do a single document response to every question that's asked.
Yeah, so that's fine. Some of them are difficult to answer. I have had, Helen, I've had a contractor offer a reduction if we didn't take a PCG as they get internal charges. I just can't see how they're taking on extra liability, i.e. liability of another group company. But in fact, it's not going to cost them anything unless somebody brings a claim against them. But sometimes we have to look to the parent company for that sort of added protection. And I think it's going to become more and more important as time goes on. Also, whilst you're doing your contractor checks, as I said, it is worth checking behind the actual company and who's providing the guarantee if you're lucky enough to get one. I've not, probably about 80% of contractors are okay with providing them where they have a parent company, and I've had pushback in some instances. Most of them are okay. About 70% people accept our standard drafting for parent companies. Some really push back and limit the guarantees, so you've got to watch out for that. And likewise with the bonds as well. Yes, Owen reads, presumably the performance bonds comes at an additional cost. We usually accept PCG in lieu of performance bonds, but yes, I think definitely. So I'm going to say something that might be controversial, but sometimes when I get involved in a project and the project manager has led the project to date, they have maybe advised for one or the other, and then I sort of railroad in and say, no, ask for both, because I just think at the outset of the contract, ask for everything you can get, all the protection you can get, and then you have a bit more bargaining power maybe when they start to exclude things from the drafting, or they try to. A performance bond will always cost. Again, the exact cost I'm not very sure of. I can get some examples after this and send them to you, Owen, if you want. But yes, a performance bond will always cost. Usually the contractor should price for that in their tender, because they'll see the drafting in there, and it's up to the client then whether they're willing to weigh up the risk of the cost of the bond against the security of the 10% that the bond will give you at the end. Also bear in mind, smaller contractors are less likely to get bonds. And the other thing I would say as well is, I have vast experience of contractors saying, I can't get a bond, when they've not actually looked into it at all, because they're not prepared to price for it, and they will just automatically say that. So do your research, push them a bit, see if they can get a bond, and then at least then you can decide whether to pay the cost of that bond.
Okay. I think that's all of the questions that were put forward through the group. Like I say, I will work with you afterwards. I'm going to send out answers to all of the questions that were posed and share those. I've moved you on to your last slide now, Niamh, which is obviously your contact details.
Well, contact details are there, obviously. Feel free, anybody feel free to send me separate emails about the questions that you've raised. If you want more on bonds and PCGs, I can send details on those. Helen, if you've got a specific query where you've mentioned in relation to your NEC and the bank holiday Monday, I can again just have a quick look into that. I will ask the group on our next meeting if anybody has raised that, but I suspect that the employer will suffer that as well. And then obviously in terms of procurement, apologies for not being able to answer the questions, but I will get my procurement colleagues on the job.
Not a problem. Okay. There's a few thank yous in the Q&A. I don't think there's anything particularly new in there that needs to be asked. Please do reach out to Niamh via these contact details. Further details obviously around the services are available on HEC for all members that have access to the framework. APUC would need to contact you directly. Okay.
Okay.
Thank you very much for everyone that's been on the call today. I hope it's been enjoyable. Can always send further questions to me as well if needed about any about this presentation today or any future presentations that you may want to see or be involved with. Okay. Thank you very much indeed to all.
Thank you.